There was one case where you're waiting for the postmortem report and you shared it with
Lordship,
Dr. Mudika?
Madam, absolutely.
Yes. And according to you, it's natural. Which one is that?
Introduce
Serial number?
40?
44?
44.
Huh?
Lordship, yes, 44.
Serial number?
44. 44.
44. Because it says indeterminate, it's a 17-year-old. What does the postmortem report say? Can we have it, please?
Would be civilian someone.
Yes, give that pink one.
Page 229. 229. Volume 4.
The pink volume.
Yes. Pink volume. 229. Postmortem.
And the commercial private for this.
229 is the PM Lordship postmortem. 398 is the magistrate inquiry.
229 is the
395.
pulmonary edema could be blow on the head. Brain, outer surface covered normal, obstruction shows normal. Lungs, spleen, kidneys, heart.
Administration. See, the finding is at page 398.
Let's see the inquest report. Dead body was found dying in mortuary with head facing upwards towards the west, left hand bent right from no external injury. Old granite rummy mark with 4 steel pits. Why do they overlook the findings? If you come to page 398, how can a 17-year-old just die? 398 is findings.
Lordship.
After the thorough inquiry and statements made by the official concerned, who were directly dealing with the case and death of the juvenile in conflict with law, One, that so the deceased has no health related issues, fit and healthy. The magistrate inquiry makes it out that he was not attended to at the hospital within time,
No, she is 9.
and therefore he. But if you come back to page 244, internal examination head, scalp findings, old surgical scar marks seen on left parietal region. Next, skull, old craniotomy mark with 4 steel clips on 4 sides over left parietal bone. Which means he had some kind of cranial surgery.
Not serious.
So why is that not reflected? Why is there the first finding in the magistrate inquiry had no health related issues? If you have a brain surgery or a head surgery, you surely have health related issues.
No, she was correct. Your Honor.
None of the people talk about his operation, though it's quite apparent. Old surgical scar marks.
Yes.
We'll take this to be natural.
Natural.
We'll take this to be natural because the negligence at the hospital is not something that that wasn't deliberate. That's the usual pace in a third world country. people die waiting for treatment. So that's not something. So then that brings us to the final aspects. Can we have the judgment in that case where 15 lakh was awarded?
Give it to the court. No, sure, we have an extra.
Single bench.
Division. Division, no, single. Division. Just a thrown around. Which one is that? Third one.
And it was paid within the time. This 15 lakh was paid.
Not serious.
It was deposited before the registry and then the...
And then the mother came and collected.
Yes, yes.
How old was the deceased in this case?
18. Actually.
18. That's fine.
He was first division holder also. His career-wise, Lordship was a first division holder.
Yes, just passed his
Class
class 12.
12. And Lordship, right from starting, there was a DK Basu violation, no FIR, not produced before the magistrate. And even he filed an application to the CJM for medical treatment, that was refused. So
Anyway, we are going by the figure of 15 lakh. if you are comfortable in paying 7 lakh, it means that you're comfortable, which means that once in a while there will be custodial debt. You throw 7 lakh and look the other way. The idea of compensation is twofold over here.
Lordship is correct.
One is compensation to the victim's party,
Absolutely, Lordship.
and the second is compensation which hurts you so as to prompt you not to repeat it. 7 lakh is not enough compensation. There's a precedent of 15 lakh, you paid it.
Lordship, if I may just submit, in this case, the state had agreed for 10 lakhs, Lordship.
Yes, we know the state had agreed for 10 lakhs, and ultimately the court had.
Lordship.
So there's a precedent over here. We will go by this 15 lakh. However, we'll go by 15 lakh, as we said, that we'll make a demarcation, we'll kind of make a classification. Now 30 will be 15, 30 to 45 will be 12, above 45 we'll make it 10. But 10 will be the minimum, we'll justify it. You can challenge it and then get it reduced.
Lordship. Not for a moment. Lordship,
But it must be something that you're uncomfortable with. It seems that 7 lakh you're comfortable with, and the message that will go out if we say 7 lakh is that your cops can kill anybody, and then the state will throw 7 lakh on the face of the.
Lordship, what is found from Lordship is a very, very, very genuine query, Lordship. That should never be the intention. And Lordship, I will just take, Lordship, a bit of detour from the main issue.
Yes.
In the judgment of 2017, Lordship, there are three important ingredients in the judgment. Paragraph 58 takes case only of the adequate compensation, Your Lordship.
Which
Supreme
judgment?
Court judgment of 2000, on the basis of which this suo motu PL.
Yes.
Lordship, Paragraph 58(1) talks about adequate compensation and suitable compensation, Your Lordship.
Where is the judgment? What is the
We have given a citation, Your Lordship.
reference?
2017. Relevant para, Lordship, will come to para 58(1).
And you are drawing our attention to paragraph
58(1).
58. Does it indicate any quantum or anything?
No, Lordship. Lordship, if we come to 58.3,
Yes.
Lordship, then Lordship, I take to page para 6.
Para?
6. The same judgment, Lord. Para 6 will be at page 669. Para 6 and para 9, Your Lordship. Please, if Your Lordship. Lordship, para 10. Para 10 is relevant because what is fallen from your Lordship? This judgment also has one component as to how to prevent, what is the preventive steps. Insofar as society is concerned in other cases of torture.
Yes.
So Lordship, what this judgment envisages is, so far 58(1) is concerned, which we have seized of this matter before the normal court is, whether any adequate compensation has been given, if not, whether suitable compensation should be given. But there are a number of other directions, Lordship, for paucity of time and not to deviate this court, that after the judgment we have to take preventive steps not only to prevent suicide, but all form of torture. So far society is concerned, Lordship. These directions have become mandatory because of the NHRC direction. Number 1. Lordship, so far custodial torture is concerned, I may just assess the court, Lordship. Law Commission report of 273 Law Commission report, Lordship.
Yes.
May it please, Your Lordship. There's been a number of directions, and I'll come later on, Your Lordship, how Calcutta High Court has dealt with it. Number of directions. This come to the judgment so far that is concerned, Your Lordship. But so far torture is concerned, Your Lordship, 273 Law Commission report has laid down and has directed the states to draft a legislation. Even they have a preliminary draft, Prevention of Torture Rules 2017. These are all matters for consideration. And what is followed from Your Lordship, if that becomes a law, then all aspects will be taken care of. I'm not going into that, Your Lordship, but that is a matter of consideration. So far we are concerned, Your Lordship, Your Lordship will kindly appreciate state's liability. Lordship, state's liability so far in non-contractual duty is concerned is complete, Your Lordship. In case of any negligence, we have to give unliquidated damages in non-contractual liability. And this is the case, Your Lordship, where the issue of adequate is the subject matter. Now, we have got two situations when we have to address the issue of adequate, Your Lordship. First comes under the public law. Article, if there is a violation of fundamental, Your Lordship, under public law. And what was the remedy, Your Lordship, under public law? The aggrieved petitioner had to come approach the Honorable High Court.
Yes.
Lordship. So before this judgment, Your Lordship, and before the government notification, what was the, how would a remedy, how would a aggrieved citizen claim a remedy? Right from D.K. Basu to Neela Bhatia to other judgments, I'm not going to that. These are all important judicial pronouncements where the sorry, Your Lordship. These are all important landmark judgments where the petitioner had to approach the court, and it was a judicial made decision on the compensation. And also we are aware of it, there was a long process that had to be undertaken, and then finally the liability was fixed. So adequate under public law, there was two options, either to approach the High Court or the traditional route, Your Lordship. Traditional route was going to claim damages. And there was a civil court route. So whenever there was a violation of whenever there was a violation of fundamental right, they had to approach the court and get the appropriate relief. This is exactly what happened in Meena Kumari. Serial number 6, Your Lordship. There was a 5 days hearing on that. We were there in the court. 5 days hearing, all aspects had gone into it. Now we have a situation, Your Lordship, after 2017 judgment and the government notification of 22nd.
That's a 2018 judgment of this court, 2018.
2018, Your Lordship. 2018 judgment, Your Lordship, prior to the government notification. So, Your Lordship, there were two situations prior to government notification. You have public law, agitate the matter, and court had the latitude, Your Lordship, in terms of facts and circumstances of each cases. Aggravated case of negligence, major contributory negligence, it would award. If not, if court found it very disputed, it would go to direct them to go to civil court. Now here was a case, Your Lordship, in Balsan's matter, court undertook the role of giving damages after hearing the cases for 4 days, and all aspects of the matter was gone into it. Now what has changed after government notification, Your Lordship? What was desired by the 273 Law Commission report, asking the government to legislate law on torture, that has moved one step ahead, Your Lordship. At least government earlier, it would contest, there was counterclaim, they would contest on the issue of negligence. Now after 22nd December, it is basically addressed the issues of accepting the liability, state accepting the liability of different kinds of negligence, which are not statutorily protected, Your Lordship. It was not statutorily protected. It was based on direction, judicial pronouncement, and then we paid compensation. So that is first major step, Your Lordship, that has addressed. Now in a situation like this, Your Lordship, in future, after this notification, if they can come within the category, if any aggrieved citizen come within the category of being tortured, we have got 3 cases where unnatural death was a case of torture, then immediately, Your Lordship, without taking recourse to a public law or a civil court claiming damages, they are entitled to that. And Your Lordship, the second option, Your Lordship, we had brought in a notification of 3rd May, where they say in case of any dispute with a natural and unnatural society, that notification is there, Your Lordship. We have also amended that portion to say that the dispute will be resolved by a competent court. Lordship, just hurriedly, I just give the notification. It is in the record. Second. So, Your Lordship, I'll just hand over the copy of the notification, Your Lordship. So, in case of any dispute, so technically, Your Lordship, it is not final. 22nd would not be final in case of any, Your Lordship, I'll just. It's always better to give it.
Yes.
Lordship, there are 2 aspects to this notification, not amended, Your Lordship, further clarification. One is this, Your Lordship, all the indeterminate cases, which is 7. 7 indeterminate cases can come within the meaning of this notification. And not for a moment, Your Lordship, the state is denying that they are not liable to pay. But if there's a contest, there's a dispute whether it's natural or unnatural, I read out, Your Lordship, para 9 and 10 of the Supreme Court judgment. There is no clinching definition as to what is natural or not. Only thing is this, if there's an external injury, they will come within the meaning of unnatural. So, Lordship, in case of any dispute, which is indeterminate, and in our case, we have a category of 7 cases, this notification will take care, Your Lordship. And Your Lordship, the entire thing will depend on in a civil court, so far indeterminate matter is concerned. Your Lordship, based on 2 principles of tort. First principle would be contributory negligence, and second would be comparative negligence. Comparative, Your Lordship, the half portion would be state will be responsible for the damage. The second part would be whether the principle of voluntary non-fit injury, whether the injury was caused by him or by the citizen himself, or it was totally the state's responsibility. If that 2 component is taken care of, Lordship, the measurement will come and the
Suicide will now no longer be.
Your Lordship, suicide will be. I'll come to it, Your Lordship. That is an address I'll address separately, Your Lordship. So with the amount fixed, with no legislation, statutory legislation in place before 22/12/2000, this is the major area, Your Lordship, has been taken care of. And it will be given within reasonable, Lordship can fix a time, maybe within reasonable time. That aspect can be taken care of. We don't have to come to High Court. In case of contest claim, you have to go. And if the state, Your Lordship, for some reason, frivolous reason, had allowed the case to be contested, exemplary punitive damages can be given, Your Lordship. But private facie are responsible. So, Lordship, if these 2 aspects has been taken care of, and a major step towards legislating law of torture, a law of suicide, law of quarrel, law in case of negligence by doctors are taken care of, then, Your Lordship, we have a limited scope whether the amount fixed by the state is adequate. Lordship, on that matter, my first submission, Your Lordship, would be on the adequate matter, Your Lordship, is that we have given this judgment, this notification, Your Lordship. Just for clarity, early reference, I'll just give it again. Lordship, we just come to the first page, 15 December 2022. The components are very crucial, Your Lordship. One is due to quarrel among prisoners. We never had a law guiding what compensation should be paid. The negligence of duty by prison officials. Lordship. Then negligence of medical, paramedical officers. Death due to torture, beating by police officers, staff. Torture has been taken care, and that due to suicide committed by prisoner, 5 lakhs. So, Lordship, these are different components that never existed, which was never in place. State has never taken it, had left the citizen to agitate the matter either in the public law domain or in the civil court domain. But for the first time, Your Lordship, this criteria has been crystallized in form of liability to pay. And, Your Lordship, how did we arrive at that? That is the issue, whether it is adequate. Lordship, I'll just come to page 3. Lordship, we will just come first to page 4, then I'll come to page 3, Lordship. Page 3. The page 4 is relevant, Lordship. Lordship, Haryana government was the first state to formulate this policy. And it had formulated on 29/6/2001. Haryana government, page 4, Your Lordship, was the first state to formulate this policy on what should have been adequate. And they had done this on 29/6/2001.
21.
21, Lordship. 29 June. Now, page 4, Lordship, is the order dated 9 February 2002 by full bench of National Human Rights Commission. Ashok, we don't know what transpired, but maybe there could have been some understanding between Haryana or between the National Human Rights and Haryana to formulate a policy, and they would test the, in terms of consumer index, they would test whether the rates are correct or not. So, Your Lordship, 9th February 2002, this is the proceeding. Lordship will hurriedly come below the notification, Your Lordship. The same amount due to quarrels, para 4, Your Lordship. Quarrels among prisoners, torture, beating of prisoners by that 7.5. Then all other categories, Your Lordship, in the next page, suicide, negligence in prisons, officials, 5 lakhs. Now, Your Lordship, if you come to page 5, the second paragraph. The issue was deliberated upon by the Commission. And considering the prevailing value of money, Lordship, I'm pausing here for a moment. They have not discussed the nitty-gritty of the money part, but on the prevailing value of the money, the aforesaid notification appears to be appropriate compensation to be awarded in such cases by state government, besides other similar liability which may be enforced in accordance with law. We request the various state government entities to bring such policy as framed by State of Haryana, with notification dated 29/6 by quantifying compensation on account of death of prisoners confined in jails, either by fixing the same amount of compensation or any other amount of compensation fixed by state. Next, last line is important, Your Lordship. The Commission should also follow the same yardstick for the time being while recommending payment of compensation in such state. So the yardstick, the direction was for the same yardstick and for the time being, Your Lordship. Not for a moment, Your Lordship, the state is making a submission that 22nd December is the final, and we are not going to change, we are going to stick to it, Your Lordship. For the time being, this is a stopgap arrangement to tide over. And in case of better price money index changing, the rates will be reviewed. Now, last page, Your Lordship, the Chief Secretaries of all state government union territories shall confirm such policy into the Commission within 3 months. The full court decision of National Commission requested all the Chief Secretaries to consider this within 3 months. Your Lordship, now this was the decision, and this Lordship will come to page 3, the same page, page 3. So this letter was addressed to Dr. Vijay Kumar IAS, not Chief Secretary, Government of Meghalaya, Main State Building. A direct letter was issued from the Commission enclosing Haryana's model notification and also the full court decision. So, Lordship, my first submission is this 22nd December 2022 notification. The adequate amount that we have fixed is not based on policy decision that the state has envisaged or it has come to its own conclusion. It was in compliance with Haryana model, approved by full commission, National Human Rights Commission, with a request to frame similar policy. We acted because there were two important components: the prevailing market money value, and it was also for the time being to put this law in place. Now, Lordship, Lordship, we have a situation in Tamil Nadu where the similar notification was issued, but the benchmark was 5 lakhs for all head. Now, on 23rd February 2023, Lordship will just come to, it's not pagination, but the first page, Lordship. If we just come to page 2. It was page 2, Lordship. Tamil Nadu Gazette notification. In serial number 1234, Lordship. Lordship, in 1234, we have all 5 lakh, 1, 2, 3. 1 and 2 comes within financial relief by payable is 5 lakhs, all 5 lakhs, Lordship. In case of police torture, 5 lakhs. Death due to firing, 5 lakhs. Rape by police, 5 lakhs. Permanent incapacitation, 5 lakhs. Death in police torture established, 3 lakhs. All these different notification, Lordship. Then your Lordship will take your Lordship to page 5. Page 5 is before the last page. Lordship, kindly allow me to read the first line, page 5. The National Human Rights Commission in a number of cases has consistent stand that it is an obligation of the state to ensure safety to the person while in custody. It admits of no exception and has been stressing for sanction of enhanced compensation. Actually, I'm emphasizing on the word enhanced compensation. To the victim of police torture and firing, considering the recommendation of National Human Rights Commission arising Consumer Price Index. So there are two parts, Lordship. Recommendation and also the Consumer Price Index. Government has decided to enhance existing financial relief to the victims of the legal heirs of deceased, victims who were tortured and injured by the police, prison officers, and also incidents of death due to police torture. Death due to police firing, rape by police are directed that the payment of compensation to the victims firing shall be made on following rates. Lordship will just come to number 1. From 5 lakh, they have enhanced it based on the same National Human Rights Commission direction and the Consumer Price Index to 7.5 lakhs. Death due to police firing from 5 lakh to 7.5, rape by police 7.5, permanent incapacitation 5. So in other words, Your Lordship, from first notification, my submission, Your Lordship, was this: if the first Lordship will see the preamble of the first notification at page. Sorry, Lordship, I'll not bother with that. The first notification, Your Lordship, was for 5 lakhs. After the National Human Rights Commission direction on the Consumer Price Index, it was enhanced to 7 lakhs. Lordship, for a moment, if I pause, Tamil Nadu is a big state, Your Lordship. It's a big state, unlike state of Meghalaya. And there, Your Lordship, I don't want to debate, Your Lordship. There was a major issue arose in Tamil Nadu 2 years ago. There was a case of a brutal murder of a father and son. And that has led to so many things happening. But my respectful submission, Your Lordship, is this: the same human rights direction was considered in 7.5.
Thank you. Yes, Dr. Madhikar.
My Lord, brief reply, my Lord.
Yes.
My Lord, my friend was trying to persuade Lordship about the category of compensation, my Lord. And he talked about contributory negligence also, my Lord. That quantum will be determined the way. My Lord, in my humble submission, my Lord.
There is no distinction over there.
This is a case of absolute liability, my Lord.
Vicarious liability. The state is responsible. And we find the classification based on quarrel, suicide, and thing to be obnoxious.
My Lord,
Obnoxious.
that's what I was trying to submit, my Lord. If you bring in
Any kind of death, if it is unnatural, it's unnatural. If it's natural, it's natural. Natural, you are not to blame. Unnatural, you are supposed to be responsible for the custody for the person. If he suffers a death, Mr. Khan's favorite Section 106 of the Evidence Act.
My Lord, in my humble submission, Lordship will apply the principle of absolute liability, my Lord, not of strict liability where there are exceptions, my Lord, in this case.
So that is what we are doing, and Human Rights Commission or not, we have the mandate of the Supreme Court. Suitable compensation.
My Lord, even this Human Rights Commission, it says, my Lord, I think my friend has not highlighted that part, my Lord. It says, my Lord, the issue was deliberated upon by the Commission and considering the prevailing value of the money, the aforesaid notification appears to be appropriate compensation to be awarded in such cases by the state government, besides other similar liabilities which may be enforced in accordance with law.
Besides
Other similar liabilities which may be enforced in accordance with law. So, my Lord,
We agree to it.
my Lord, there are two aspects, my Lord. State issuing a notification, my Lord, fixing the quantum of compensation, that is one aspect. But a constitutional court deciding the matter, my lord, is not bound by the notification issued by the state government.
We will only provide, we will make that classification according to age. That I think would be a reasonable
more
classification
rational.
because even motor accidents also we have that yardstick of the earning capacity. Based on the earning capacity, we will make no distinction between natural death, whether you pinch him to death or whether you punch him to death is the same thing.
My lord.
And the other thing we are going to talk about is suitable compensation, and as a deterrent, we want to make it this is not something that they are comfortable with, something that they are uncomfortable with is what should be the basis. And finally, what we are going to say is that this amount will be in addition to any insurance or regular claim that they will be entitled to. This amount will not cover insurance or other regular payments that otherwise that also would be. Of course, these people would hardly have any insurance, but in case they have, this should be over and above as compensation for the fate that the victim meets over and above, whatever the next of kin would get in case of insurance.
My lord, I was only trying to submit, my lord, on the strict liability and absolute liability, my lord. In strict liability, what my friend is trying to say, my lord, there are certain exceptions to that, my lord. One of the exceptions is contributory negligence, my lord, act of God. But when you come to the principle of absolute liability, my lord, there are no exceptions to that. And once there are no exceptions, my lord, there cannot be sub-classification of that, my lord.
Now, of these, there were therefore 50 cases we found out.
My lord.
How many are natural and how many are unnatural ultimately?
My lord, 21 are natural.
20?
21 are natural, my lord.
Let us just count it once.
My lord.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24. 24 appear to be natural. Let's count the unnatural. 1, 2, 3. One is compensation awarded.
Yes, my lord.
So we are not counting that. So we are taking 49 cases. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24. 24 are unnatural, 25 natural, and 1 is compensation already paid. As to the cases where, Mr. Khan, we are taking it to be unnatural, you are not contesting.
No. But Ashok, if I may just submit, allow me just to clarify. Once natural goes and unnatural, the suicide part goes. Unnatural, there are two unnatural categories, Lordship.
Yes. Suicide we are including in unnatural.
Lordship, it is included. Okay, Lordship. So suicide all by hanging goes. So
Suicide or hanging are...
So we have a situation, Lordship. Third category is the indeterminate. And my argument is, Lordship, like...
there is no indeterminate over here.
No, there are 7 cases, Lordship.
There are no indeterminate over here.
Unnatural indeterminate.
Which ones? Which ones are according to you indeterminate?
Lordship, 1.
Number 1 according to you?
1, 9.
Just a second. Just give us some time to organize ourselves.
Lordship, this is on the basis of the observation the court made the other day. Right.
according to you, one is natural
Lordship.
and
One is indeterminate.
no.
Okay.
We say it's unnatural. We find scalp and soft tissue of neck injuries of 2 days duration, multi-organ lesions. We find it. We leave it open to you to argue, but we find it to be unnatural.
Okay, Lordship.
So that's number one.
Number 9, Lordship.
Number 9. Rajiv Marak, 25 years. You have not shown anything. You have not shown anything.
No, Lordship.
The
Only presidential inquiry said there
burden
is
is on you.
no foul play, Lordship. The finding is there is no
The burden is on you
Absolutely, Lordship.
to demonstrate that it was a natural death.
Lordship.
You have failed to discharge the burden because over here, it's a 25-year-old. 25-year-old won't die suddenly.
Lordship, we
He
are
was
relying on
found dead in a sleeping platform in a sleeping position. Cause of death has been resolved. Final opinion will be given after FSL report. No FSL report produced. So therefore, we do not know, and therefore
the burden is on us.
the burden is on you, which you failed to discharge. We'll take it as
We
unnatural.
are relying only on the limited finding of the magistrate that there was no foul play. That is there, Lordship.
That is
Page 273.
irrelevant.
So because Lordship, as state, Your Lordship, I'm making a candidate submission, Your Lordship. We are taking a very neutral stand. We are not trying to argue this way or that
No,
way.
very well.
It says no foul play, Lordship. I'm just going to read what is written there.
Yes.
Except if the court wants to have a different opinion.
Yes.
And then 14, Your Lordship.
14. Again, 29-year-old. Cause of death undetermined, cause at death at postmortem, then thereafter, your magistrate says no foul play.
420, magistrate says, Your Lordship, negative for chemical poison and report from negative indicate that deceased had a heart and lung disease. That is at page 420.
Page 4.
420 and 421, Your Lordship.
Unfortunately, the thing ends at 400.
Volume 1, Your Lordship. Sorry. Volume 1. Yeah. 420, Lordship, clause 8, Dr. P. Ramsu. P. Ramsu. In the last paragraph, Lordship, at page 421.
No, where is the medical thing on which that report is based?
Medical.
A report from Negrims indicated that this is at, where is that report from Negrims?
No, we don't.
Then,
But there are different reports, Lordship, which is our page. I don't know. This not. We have to go through. Which will require some time at least because there are a lot of pages involved. 403, 405, 408. These are different reports.
was the Negrims report?
We as per our chart, Lordship, we have not annexed. But Lordship, we just come to page 421, the last paragraph, 421.
That doesn't mean anything unless we see the
Lordship,
thing.
Lordship.
So that is number 14,
Yes.
page 421, volume 1, unsubstantiated. Which is the next one that you contest?
16.
24-year-old. 16.
Lordship, no visible injury, which is at volume 2, page 31.
Yes, 24-year-old. Cause of death is till the FSL HPS. Have you proved that?
No.
That is volume?
Volume 2.
No, just keep it over there. Yeah. Is there anything to show?
Nothing much, Lordship, except the post-mortem says no visible external injury.
Maybe. He was found unconscious on the floor where he used to sleep. He was not breathing, his heart was not beating, he was taken to civil hospital. External injury is nil. Cause of death undetermined.
Lordship.
And cause of death is resolved to the FSL and HPS. What is HPS?
This is some histopathology, Lordship. This is.
Oh.
Mr. Patel.
So if the FSL report is
But
given.
findings at page 47, Lordship. Page 47, volume 2. The last paragraph.
What kind of magistrate is this? Judicial magistrate. Executive magistrate's finding is your servant.
We admit that they have just reported the finding without relying on the actual documents.
No.
It's
Unacceptable. Next.
Next is 26, Lordship.
26.
Volume 2.
26.
Page 37.
Multiple injuries.
Multiple injuries, Lordship. We find it page 230, volume 2.
26 is Toyam Sheikh,
Age 37.
age 37.
Multiple injury, Lordship. 230.
Yes. What does the report say?
Liver, brain, spleen, kidney are congested.
Liver, brain?
Spleen, kidneys are congested. Lungs, larynx congested. Heart enlarged.
No, what is the conclusion?
Conclusion is, Lordship, he was a heart patient. Disease died due to incidental complication from surgery, then malice afterthought. Page 233. Conclusion at page 233.
Previous page. That's neither here nor there.
But if you read to page 232, histopathology report and FSL report, which is 232.
But there are so many injuries. Any medical report to show surgery or whatever?
No, we have not really. Except page 232 F.
Chronic pericarditis. What is the report of chronic pericarditis and complication from surgery? Where does he arrive at complication from surgery?
No, unfortunately, Your Lordship, the magistrates have not annexed.
And look at the cause of death over here. Complaint of fever with difficulty in breathing on 5th September. He went to Tura hospital. Then in Tura, his condition deteriorated. He was referred to Negrims on 30th September. On 2nd of October, he was shifted to ICU and was diagnosed with severe cardiac abnormality. Subsequently, he was taken, so we will put this down as natural. Because these injuries may have been previous injuries, but do not appear to have any nexus with, he was suffering. He was suffering, so this is number?
26.
Number 26. So number 26 becomes natural.
Next we have 27, Your Lordship.
27.
27 is a drug user. Volume 2.
FSL report?
We have inquest report, Your Lordship, no FSL report.
Page.
Page is 244. 244.
Minor. Let me see. It could have been an old injury. Cause of death?
Your Lordship, page 288 is important, Your Lordship. Deceased was known case as IVDF, intravenous drug user.
Yes.
And OST was advised on 6/12/2016, but he declined. That is page 288.
288.
288. And then he was immediately referred to hospital on 288.
He was referred to a hospital in 2020
Lordship, yes.
and he died 8 days later. And he was taken into custody in 2016. Under trial or
Judicial custody, Lordship.
under trial?
Under trial.
Convict, we'll take it differently because convicts are generally not beaten up unless, there's a fight between them or a fight with the warden or
Clause
something
of
like that.
quarrel among prisoners.
Quarrel.
Lordship is correct.
Convicts are, but
Convict stand.
UTP is subject to
Trial.
torture.
Torture.
Because, the inquiry and things like that. This is UTP.
And then, Your Lordship, then we'll have to also address the issue if UTP whether charge sheet has been filed or not.
That
Because post charge sheet, Your Lordship, they have nothing, no role.
the external injury in this case does not appear to be, severe.
278, Your Lordship. Minor injury.
Yes.
278.
And this thing could be a drug user. We'll give you this one, 28. 28 or 20?
27.
27. 27 in any event we marked as natural.
Natural. And 44, Lordship, we have addressed it as natural.
44 we marked as natural.
Then, Your Lordship, next we have two important categories, Your Lordship. That is list of convict who died with an external injury. In other words, that will come within the meaning of torture. Those are serial number 7 and 50.
Yeah, those we marked as unnatural.
No, Lordship, unnatural suicide will have a different criteria. Lordship, at least allow me to submit on that separately. Because when it comes to torture, Lordship, there is hardly any scope for me.
No. It need not be torture. It may be picked up a quarrel with the one of the wardens, beaten up.
Beaten up. So, Lordship, we have to go detail whether there was an external injury.
We've seen that. Seven days sufficient.
7 and 50, Lordship.
7 and 15.
Lordship.
7 days sufficient.
7 and 50 are in isolated cases,
7 and 50.
50. Volume 4.
Let us take 7.
7 is at volume 1. 35 years.
Gotcha.
Lordship, if I may assess the code, different parts of the body caused by blunt trauma, which is at page 215.
UTP or convict?
Police custody, Stockport.
Yes.
UTP. This case may require independent consideration, Your Lordship.
No, this we are taking as unnatural.
No, unnatural plus torture would be in a very separate category.
No. We are not categorizing torture. Everything is same.
But Lordship,
Suicide, torture, whatever, death in your custody is death in your custody.
but there has to be some.
We are not butchers that will make a choice between, the leg and the heart and the liver.
Not that, Lordship, only for the purpose of quantification.
No, quantification is uniform. Quantification is uniform.
But Lordship, allow
You
me.
are responsible for that. We just exercise your argument. Go and get it corrected elsewhere.
Lordship, that is not the intention. I'm just trying to assess the code.
We are not impressed at all with your categorization. You kill them, you are liable for the entirety.
Lordship, but that categorization is not done by state per se.
Whatever, whoever has done it, we are not impressed.
And the National Human Rights Commission is also not before the.
Let it go its own way. What value does the Human Rights Commission have with that chairman?
Lordship will kindly appreciate. At the end of the day, it's public money which the hearing officials have committed a crime.
Yes, public money, you should educate your officers.
Absolutely, Lordship.
You should educate your officers not to do it. It will act as a deterrent.
Lordship, in Meena Kumari, Balsan matter, that is exactly where the court observed that the charge sheet was filed against the hearing officials and they were supposed to realize the money from them. What was fallen from your court, Lordship? Allow me, Lordship, just to clarify
That we will leave it open to you for instituting proceedings and recovering.
But Lordship, what is fallen from your Lordship that the state should bleed? Lordship, kindly allow us to address the issue. We are not denying the liability, Lordship. But and also the classification is required, Lordship, because for various reasons, Lordship. So Your Lordship, so far 7 and 50 is concerned, and I'll have to assess the call also, Your Lordship. When it comes to blunt object torture and see Lordship see 50, that
Tell us when you're
due
finished.
to head injury.
Tell us when you're finished. We will not shut you down.
No,
But tell us when you're finished. Because to us it makes no difference.
No,
Blunt or sharp, suicide or torture, slip or push, make no difference at all. You are responsible for the citizen who is in your custody. You can remove him from the rest of the society, whether as a convict or in course of investigation, in police custody or judicial custody, but you are responsible for his well-being. Anything happens to him and we discover the slightest sign of unnaturalness about it,
Lordship, that is precisely what I meant. I submitted. I said that had never happened before 22 December. That issue had to be agitated under public law or civil code. Right now, Lordship, right now.
nothing. There is no justification in that order. It's a perfunctory one-page order endorsing something without any reasons. And we'll have occasion to write about it.
But Lordship, assuming Lordship, for a moment, not that I'm going to disagree with the court, assuming now, Lordship, your Lordship overlooks this notification and passes a different order. Now, this is a policy decision of government based on. Now, what would be the future guidance for compensation? Whether it will be decided by this court's judgment.
We'll set aside the notification.
Again, Lordship, that is the query, Lordship, but there is an additional development that has happened on 28 July. We had given compensation, Lordship, it said keep that in a bay. There has been subsequent development, Lordship.
Which one?
On 29 July, Lordship, we had informed the court that based on the query that had fallen from the court, the government took a decision not to enhance the query raised by the court, but to comply.
Bad luck.
We have paid
Bad luck. We'll do it one way. The government has its options to challenge the order.
Lordship, we have, based on the notification, none of the kith and kin agree with the notification and refuse to make it.
The kith and kin do not concern us.
And
In many cases, the kith and kin will not even want to come up and take the compensation.
absolutely.
Because they may be ashamed of the original conduct of them.
But
Someone in POCSO, someone a drug addict, someone involved in heinous crime. The kith and kin, the next of kin may be unwilling to take
Lordship is
it.
correct.
We'll provide for, in that case, that money has to go somewhere else.
Lordship is correct.
But the state has to pay that.
But they have taken the money, Lordship. For a moment, Lordship said Lordship is going to overlook the policy. Lordship, kindly appreciate there will be two consequences. First, none of them are challenged. Rightly so, they were not in the position.
Better for you.
Lordship, no.
Better
Second,
for you. Our order adds to confusion. Better for you to get it
Lordship,
correct.
first, that is my first argument. Lordship, second would be, even the amicus are aware of the notification and whether he is not challenging the validity, whether this is inadequate or adequate. So we have two situations, Lordship. Lordship, we have two situations where the notification itself will not remain challenged.
Yeah.
No, Lordship, kindly record at least my submission. I am not for a moment. I am
Yes,
asking.
we'll record it as part of the absurdity.
Absolutely. Not for a moment.
Part of the absurdity will record it. Don't
Absolutely, Lordship. Not for a moment.
Yeah. 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 That will be the benchmark. Yeah.
See, so Lordship, before
There have been, now this suo motu public interest litigation was initiated pursuant to a direction issued by the Supreme Court in the judgment reported at 2017 10 SCC 658 bracket re inhuman conditions in 1382 prisons. Hooks up. Two aspects must be pointed out from the relevant judgment. And puts up. The first is that a distinction was sought to be made by the NCRB is the National Crime Records Bureau.
Yes.
By the National Crime Records Bureau, between natural and unnatural deaths in custody, full stop, at paragraph 16, paragraph 6 of the judgment, comma, the Supreme Court found the distinction to be unclear. Secondly, comma, on the issue of defining natural and unnatural deaths, the Supreme Court went on to observe as follows at paragraph 9 of the report, colon, set out paragraph 9. Paragraph. After considering several reports, recommendations, and submission and suggestions made from several quarters, certain directions were issued by the Supreme Court in the relevant judgment at paragraph 58 and the various subparagraphs thereunder. Full stop. For the purpose of the present proceedings, comma, paragraph 58.1 of the report is relevant, comma, as has been rightly pointed out on behalf of the state. Full stop. Paragraph 58.1 quoted. Please set out paragraph. In course of the present proceedings, it has come to light that there have been 50 custodial deaths in the state since 2012. Full stop. Detailed reports have been filed by the state indicating the likely causes of death in each case, comma, appending copies of the post-mortem and inquest reports, comma, sometimes relying on reports furnished by the Forensic Science Laboratory or even the histopathological reports, and comma, finally, comma, the findings of the magisterial inquiry, comma, albeit such inquiry is being conducted by an executive magistrate in each case. Paragraph. The 50 cases of unnatural deaths are the following. Are as per the following table. Full stop. Make a table. First will be the serial number 1, 2, 3, 4 like that. So there should be 2 spaces in that, no more than that. The next one will be the name. The third one will be the age. The fourth one will be cause of death. So cause of death will have the maximum. First is Bulbin Marbanning, 47. And then we said name, age, and cause of death. Cause of death was the UTP allegedly collapsed and was declared brought dead at the civil hospital. Then I'll make another column on the right, remarks. Since the state has not been able to conclusively establish a case of natural death, comma, despite the burden being on the state, comma, this is regarded as a case of unnatural death. Next, to Roy simply, you'll get the names and things, we'll give you the chart, but that's only for verification, you write it. 20, death by hanging, unnatural. In the remarks, unnatural. 3, Topo A. Marak, 19 years, long time drug abuse, no external injuries, natural. 4, Alson D. Sangma, 30 years, death by hanging, unnatural. 5, Rajendra Ravi Das, 60 years, suffered from several ailments, natural. In the remarks. 6, Balsan S. Marak, 20 years, torture, last column, unnatural, then below that, dealt with in High Court judgment of February 28, 2018 and paid rupees 15 lakh as compensation. Next, 7. Whitson, W-I-T-S-O-N, Whitson M. Sangma, 35 years. Death, you in that column you say injuries revealing torture, remark is unnatural. 8. Senuman S. Marak, 19, death by hanging, unnatural. 9. Rajiv Marak, $25, then death, allegedly found dead in his sleep, full stop. No FSL or histopathological examination report. Remarks, unnatural death since state has failed to demonstrate to the contrary. 10. Norbert Malmgiang, 33 years, death by hanging, unnatural. 11. Sovraj, Sovraj Sonar, 32, death due to shock and brain hemorrhage. Unnatural. Since state has been unable to indicate the cause of death. 12. Cleophas Nonclaw, 29-32 years, death by hanging, unnatural. 13. Sattar Khan, 54, intracranial hemorrhage, natural. 14. Tanbor Dakar, 29, though no external injuries detected, no cause of death furnished by state, unnatural deaths. Now, unnatural, then, next line, unsubstantiated finding of executive magistrate, disregarded. 15. Lolin Sangma, 67, death, myocardial infarction, natural. 16. Shamol Ali, 24 years, though no external injuries, FSL report not produced, no proper cause of death shown by state, remark unnatural, next line, unsubstantiated finding by executive magistrate disregarded. 17, 40 years, Everlyn Shadab, Everlin, Everlyn Shadab, 40 years, chest and abdominal pain, was in civil hospital for considerable time before he died. Natural. 18, Bablu T. Sangma, 30 years, death, pulmonary and hepatic lesions, natural. 19, Sudhir Magar Thapa, 47, paralyzed from waist downwards, full stop, was under long treatment, full stop, died of the ailments, natural. 20, Skember Kindait, 34, long drug abuse, natural. 21, Dringley Roy Ringide, 82 years, old age problems, natural. 22, Tangkam N. Marak, 34 years, alcoholic and chronic alcoholism, death due to chronic liver failure, natural. 34 years, okay. Next, number 23, Toyanath, Toyana Dahal, 60 years, cancer, natural. 24, Sujan Marak, 66, long history of hypertension and blood sugar, natural. 25 Ajay Das, 42 death by hanging, unnatural. 26 Tayom Sheikh, 37 years, though several external injuries evident, they appear to have been old, diagnosed with cardiac abnormality, natural. 27 Ralang Suting, 34 years, death, long-term drug abuse, natural. 28 Haplin D. Sangma, 43 years, death due to heart condition, natural. 29 Dilwar Hussain, 20 years, death by hanging, unnatural. 30 Meng Hongsingi, 74 years, death is age-related ailments, natural. 31 Lakhvinder Singh, liver cancer, natural. 35 years. Liver cancer, natural. 32 Saman M. Sangma, 32 years, death by hanging, unnatural. 33 Janet Jakai, 55 years, poor heart condition, natural. 34 Raju Koch, KOCH, 23 years, cardiovascular insufficiency, natural. 35, just follow it, correct us if you have.
Yes.
35, Devon Dole, 30 years, cancer, natural. 36, Chloelan Marbanian, 37 years, respiratory distress and COVID, full stop, cancer of tongue, natural. 37, Madaini Mohila, 41 years, death by hanging, unnatural. 38, Salvian N. Sangma, 22 years, death by hanging, unnatural. 39, Naresh Kok, 44, several external injuries, death by hanging, unnatural. 40, Nalchand Ali, 40 years, death by hanging, unnatural. 41, Silbalin M. Sangma, 18, death by hanging, unnatural. 42, Bernard T. Sangma, 34 years, coronary artery block, natural. 43, Borit D. Sangma, 30 years, heart attack, natural. 44, Wanglanki Dakar, 17 years, no conclusive report produced, remark, unnatural. Huh? 44?
44 was natural, was it?
Just a second.
Natural.
Oh, 44, sorry. Oh, 44 is
Natural.
the thing, cause of death is cardiomyopathy with pulmonary edema. Yeah, my numbers got mixed up. So natural. 45, Bantelang Jerwa, Jyrwa, 27 years, death by hanging, unnatural. 46, Nirupam Dhar, 21 years, death by hanging, unnatural. 47, Hardik Harting, 56 years, death by hanging, unnatural. 47, 48, Ravi Kumar, 32 years, death by hanging, unnatural. 49, Rakesh Singh Rajput, heart attack, natural, age is 45 years. 50, Tebester Thaba, 40 years, several external injuries, unnatural, full stop. Postmortem report indicated death might have been by physical assault. We counted whether or not how many we have. Thus, paragraph now, after the table is over. Thus, comma, in all, thus, comma, out of the 50 deaths in custody from 2012 till date, blank,
Lordship, which is assessed the court. We had filed an affidavit on 16 September 2022. Based on the information given by the MA case, Lordship, we had brought in 2 more names. Both are suicide case.
so there are 2 more.
Lordship, I'll just assess the court. The name and the age only, and they are suicide. 23/8/2022, this court was pleased to direct us to file an affidavit.
What is the name, Mr. Khan?
Lordship, the name is Kidbok Khasar.
So it will become 52.
His age is 24 and cause of death is suicide.
51 is
Kidbok,
Kirbok Qatar,
Kassar, Khasar,
KSSAR, 21 years,
24 years.
24 years, death by hanging, unnatural.
And second is Dapha Salani Rupong. DAPHAH SALANMI Salani RUPON. Age is 26. 26.
26, death by hanging, unnatural. So therefore, that's, yes,
One affidavit was filed by the state government on 9 December, wherein the name of John Shalom was mentioned at serial number 39, my lord.
yes,
But in the table dictated by your lordship just now, it appears that the particular name has not come. Serial number 39, affidavit dated 9 December.
serial number 39. Serial number 39 with us is Naresh Koch.
My lord, as per the affidavit, that is at serial number 40.
No, we are going by the serial number of whatever is provided by Mr. Dr.
In fact, at
What is the
serial
name?
number
What is the
40,
name? Give us the name.
the name is John Chalam, John, John, CHALLAM, Chalam.
I thought we had agreed all this. That name is not there in that list.
That list was given to us, my lord. The one provided by the learned matters curate.
Is that an additional name?
No, it was not part of the.
It's part.
My lord, that is not a traditional name. The name that has been mentioned at serial number 42 by your lordship just now, that name does not appear in the state government's list.
32.
42.
42, my lord.
42.
Bernard Sangma.
Bernard Sangma is not there in the state list.
Bernard Sangma had 2 names.
My lord, there is Boris D. Sangma, 43.
Yes, he's the same, Elias. Elias.
But no, my lord, but then that name is not in the affidavit filed by the state, Bernard Sangma.
Yes, this Bernard Sangma was also known as
Bablu Sangma.
Bablu T. Sangma.
Bablu T. Sangma, my lord, it was already there. Your lordship had dictated.
No, but this is 42, 43 is Boris Sangma.
Yes, my lord. 43 is Boris Sangma.
John
Bablu
Chalam,
T.
where does
Sangma-
it come from? This is the state's list. Mr. Khan, this is your list. Item number 39.
Bablu T. Sangma is at serial number 18, my lord, in the state's list.
John Chalam does not figure in your list, Mr. Mudika.
It is not as.
No, man.
Affidavit dated 9/12.
Yes, where do we stand, Mr. Khan?
John Chalan is there in page 39.
Is John Chalam's name included in any of the volumes?
Volumes, no. Any of the volumes, no. Not none of the volumes.
Yes,
about
yes,
it.
yes.
But we,
It is there.
volume 3.
John Shalom, as per affidavit, is volume 3, my lord.
But there's nothing, no details.
Nothing, no
details.
details.
No details.
No details.
Just the
no-
name is the blank.
Only the name and the blank. No PM, no.
And you admit it to be unnatural.
No, sir.
What is the cause of death?
No, we don't have, Your Lordship. Neither post-mortem, no.
Very well, we'll put it as, and when, what is the date?
Date is
Date is 14/6/2022.
14/6/20.
22.
So, 20.
2022.
Or 2022. So therefore,
My lord.
what is the previous one? What is the next one?
Which point?
And my lord,
Naresh Court.
serial number,
40, which point?
yes, my lord, that is next
Naresh
narration.
Court, no, 39 is Naresh Court.
And I will just 39, but then the John Chalan was there.
So Naresh Court will become, Naresh onwards will be 40. So all of them will increase. And before Naresh Coach add 1, 39 will be John Chalam, age not indicated, cause of death not indicated. Oh, hanging. No. Cause of death not indicated. Unnatural. Then state accepts that this death was unnatural. All right, so it brings it, how many now? 53.
But my lord had just stated that Bernard Sangma was with alias as Bablu. Bablu's name is already there in the list at serial number 18. my lord.
All right, man, we followed you. Yes. So how many does it take? That comma, and so the previous will also be amended, not 50 to become 53. Thus, comma, out of the 53 instances of custodial death in the state of Meghalaya since the year 2012, comma, blank are found to be natural, blank are found to be due to natural causes, and the remaining blank are found to be cases of unnatural death. Paragraph. It must be recorded that the state has contested the cases of Bulbin Marbaning, Rajiv Marak, Tanbo Dakar, Shamol Ali, and Shamol Ali, on the ground that there is no material to suggest that any of the deaths in such cases was unnatural, whether from any external injury or from the post-mortem report, full stop. In addition, the state submits that the finding of the magisterial inquiry would go to show that there was no foul play in any of these cases and the persons may have died of natural causes. Full stop. Paragraph. The basis for the assessment in the present case must be laid bare. Full stop. While the state has every right to arrest a person during investigation, subject to following the procedure established by law, or depriving a convict of his liberty by reason of the sentence that he has suffered, when a citizen or any other person is in the custody of the state, the state is responsible for his well-being. Full stop. If such person dies, unless the state is able to affirmatively establish that the cause of death was natural, it would be inferred that the person died of unnatural causes, the person died an unnatural death. Full stop. In each paragraph, in each of the cases that the state has contested, the age of the relevant under trial or convict or the physical condition of the person did not suggest that, did not indicate that the death was due to natural causes. Full stop. At the same time, no external injury may have been discovered or anything apparent to suggest that the person had been tortured or died as a consequence of any action by the police or jail authorities. Full stop. However, as indicated, if the state cannot establish the cause of death while in custody, it would be inferred that it was a case of unnatural death, particularly when the deceased is found to be too young to suffer such fate. Paragraph. In the Supreme Court judgment, pursuant to which the present matter has been taken up and considerable time expended to determine the number of cases and the causes of death in each case, the direction to the High Courts was to award sufficient compensation. Full stop. The sufficiency of the compensation would have two aspects, colon, the compensation due upon a life being snatched long before death may have been due, semicolon. The other part, now on the other hand, comma, the sufficiency of the compensation should be such that in a civilized society, there would be no unnatural death while in custody. Full stop. The compensation has to be both compensatory and punitive so as to act as a deterrent. Full stop. Paragraph. It appears that in December 2022, the Haryana government notified not December 22, in June 2021, the Haryana government notified rates of compensation by making a classification of the cause of death while in custody. The classifications were dependent on, now the quantum of compensation was dependent on whether the person died on account of a quarrel among inmates, or due to torture by officials, or due to negligence, or by suicide and the like. The relevant notification also provided that if death occurred due to natural causes or while trying to escape from the correctional home or from custody, comma, no compensation would be payable. Full stop. Paragraph. By an order dated February 9, 2022, the National Human Rights Commission merely noticed the Haryana notification of June 29, 2021, comma, set out the entirety thereof in its order of such date, and requested state governments and union territories, open quote, to bring such a policy as framed by the state of Haryana, by quantifying compensation on account of death of prisoners, close quote. Paragraph. There does not appear to be any independent application of the mind of the Commission, comma, despite the order dated February 9, 2022, bearing the signature of all 5 members. Of such commission. Full stop. In any event, comma, apart from the fact that the order of such commission may not be binding on this court, comma, there is an independent mandate by virtue of the Supreme Court judgment of 2017 for the High Courts to fix suitable compensation, or suitable or sufficient? What is the word? Paragraph? Suitable compensation. To stop. The suitability within court suitability has already been seen to consist a component of sufficiency and another which would act as a deterrent. Full stop. In tune with paragraph, in tune with the Haryana notification and the rather perfunctory order of the NHRC, the state has come up with a notification on similar lines. The state also relies on a near identical notification issued by the state of Tamil Nadu on February 23, 2029. Full stop. Paragraph. According to the state, it was following the report of the 273rd Law Commission which required states to legislate against death on account of torture, that the entire matter came to limelight, full stop. The state submits that since it is essentially a human rights issue and the national body has applied its mind to endorse the classification and the quantum in each case as fixed by the state of Haryana, the court should let the matter rest, as the state has followed the same classification and quantification. Paragraph. It is the further contention of the state that ordinarily, when the next of kin of a person who has died in custody accuses the state of any foul play, a civil action for damages would have to be brought. Semicolon, though, in certain extraordinary situations, even the writ court has entertained such a plea and has awarded compensation. Full stop. According to the state, since the relatives of the person who has died in custody do not have to undertake the trouble of making a claim and proving the same in court, the quantum of compensation as declared by the state should be found to be adequate enough. Full stop. The state also submits that considering that public money is involved, the court should not allow for greater compensation as the state's resources in such regard are limited. Paragraph. For a start, the classification introduced by the Haryana notification, which has been endorsed without any comment by the NHRC, does not appeal. Full stop. Such classification begs the question as to why a certain amount should be paid for death suffered due to a fight breaking out among inmates at a correctional home, and death suffered by hanging, to which an under trial prisoner is pushed by how he is tortured while in custody. Full stop. More importantly, it is the quantification in the Haryana model which appears to be unconscionable to this court. Full stop. In the judgment of the year 2018, delivered by this court in WPC number 213 of 2014, bracket, Srimati Meena S. Marak versus State of Meghalaya, comma, upon finding that the death of the 18-year-old in that case was due to the brutalities indulged in by the state police, comma, an amount of rupees 15 lakh was awarded as compensation. Full stop. The state accepted such amount, and it is the undeniable position that the total amount has been paid. Full stop. Paragraph. Thus, comma, one such standard has already been set in the state, comma, of the award of compensation of rupees 15 lakh for an 18-year-old dying as a result of police brutalities while in custody, comma, 5 years down the line, there is no good reason for reducing the quantum. Full stop. In any event, comma, the state accepts that it has made the payment without questioning the quantum. Full stop. In the state coming up with the notification providing for a lesser amount based on the Haryana model, comma, it appears that the amount of 7.5 lakh as maximum, as suggested by the state, may not hurt the state so much as paying the compensation of rupees 15 lakh may have done. Full stop. Thus, comma, the maximum quantum proposed by the state by its notification of rupees 7.5 lakh would be an amount that the state would be agreeable to pay without any questions asked. Full stop. Paragraph. Death in custody is a slur on a civilized state. Full stop. Ideally, there should be no death, comma, except due to natural causes, comma, while in custody. Full stop. Of course, comma, the natural causes are beyond the control of the state, and convicts serving long sentences may also have age-related problems which may lead to their death. Full stop. But it is particularly distressing to note the number of deaths of under-trial prisoners as the investigating agency uses third-degree methods to get information from the arrested person rather than go out in the field and investigate the matter. Full stop. Oftentimes, the excesses indulged in by the state through its police officers result in admissions, which may be inaccurate, but which are made to stave off the further torture. Full stop. If police brutalities and the inhuman treatment of persons in custody have to be arrested, the compensation for custodial death has to be pegged at a level where the state will bleed to make the payment. Full stop. Paragraph. At any rate, there is no room to apply the strict liability theory when it comes to the death of a person in the custody of the state. Full stop. The state's liability in such regard is absolute, and unless it's demonstrated to the satisfaction of the court that the death was due to natural causes, the court may reasonably infer otherwise and hold the state liable. The state ought also to be liable for the actions of its officers and employees. Full stop. It is possible that in several cases, exuberant officials go beyond the call of duty or the SOP in place. Full stop. In such cases, the state will remain liable for the acts and conduct of its officials, but the state will also be free to proceed against such officials and even extract the compensation it has had to pay from such officials in accordance with law. Full stop. Paragraph. Though the classification indicated in the Haryana notification and as has been mindlessly adopted by the state appears to be abhorrent and obnoxious, there could be some other form of classification based on a precedent, therefore, in our jurisprudence. Full stop. In respect of motor accident claims, there is a classification of the quantum of compensation payable based on the age of the victim. Full stop. Accordingly, it is deemed fit and proper to classify those who have suffered, classify the victims who have died in custody into three categories, namely below 30, semicolon, between 30 and 45, semicolon, and comma, above 45, full stop. Paragraph. Since the judgment of this court in Srimati Meena Marak has already established the quantum, comma, the sum of rupees 15 lakh may be taken as the compensation payable for death to a person aged below 30, for death in custody of a person aged below 30, full stop. For victims in the age group of 30 to 45, comma, the quantum of compensation should be rupees 12 lakh, and for those above 45 years, it should be rupees 10 lakh. Full stop. Paragraph. Not paragraph. There is an element of subjectivity in arriving at such ballpark figures, semicolon. However, comma, when it comes to assessment of damages, quantification of compensation, comma, there is an element of guesstimation that is always indulged in. Full stop. Paragraph. Accordingly, comma, the compensation agreed to be paid by the state in the notification dated. What is your notification, Mr. Khan?
15 December 2022.
December 15, 2022 is found to be inadequate and the relevant notification is set aside. Full stop. For the period till date, in case of unnatural death while in custody, comma, the next in kin of the victim will be entitled to a sum of rupees 15 lakh if the victim was below 30 years of age as on the date of death, semicolon, a sum of rupees 12 lakh if the victim was below the age of 45 years but above the age of 30 years as was the date of death, and comma, a sum of rupees 10 lakh if the victim was above 45 years of age as at the date of death. Paragraph. All the aforesaid persons indicated in the chart who suffered unnatural deaths, all the next of kin of the aforesaid persons indicated in the chart would be entitled to compensation at the rates indicated here and above, it is more than likely that in several cases, because of the heinous offences committed or alleged to have been committed by the relevant persons, their next of kin may not be interested in contesting the proceedings or even collecting the compensation upon the death of the relevant person. Full stop. In such cases, the state will be obliged to put in the money into the cancer department of the civil hospital in Shillong for the purpose of augmentation of equipment at such fledgling facility. Full stop. The secretary in the Department of Health will be responsible to ensure that the money is disbursed by the state and upon the next of kin of the deceased victim not being available or willing to accept the payment, the money is immediately made over to the cancer department of the civil hospital in Shillong. Full stop. Paragraph. The amount of rupees 15 lakh, 12 lakh and 10 lakh in the three categories as indicated herein will hold good till the end of the year 2024, whereupon they will stand increased by 1.5 lakh at the highest level and by 1 lakh each at the two other levels for the next period of 3 years. Full stop. The quantum of compensation should be enhanced every 3 years so that it is sufficient for the next of kin and the deterrent factor is also maintained to the same degree. Full stop. Paragraph. Anything else for this? Huh? Yes, that's. Yes. Paragraph. It is made clear that the compensation will be payable only in cases of unnatural death, irrespective of the cause of death. In cases of natural death in custody, no compensation would be payable at all. Full stop. As to cases where the state suggests that the injury suffered which caused death was in course of the person in custody trying to escape, the determination of the cause would be by an appropriate court in accordance with law. Paragraph. Since all the matters pertaining to the death in custody in the state from 2012 till date have been covered, the present proceedings are closed. Full stop. It will be open to individuals or even to the court, on its own, to institute further proceedings on similar lines to ensure that compensation is paid and the deterrent acts as a deterrent on the state. Full stop. The court expresses its gratitude to Dr. Bozika, who was appointed as amicus curiae in the matter. Full stop. It may also be recorded that counsel for the state, despite the interests of the state, has been fair in ensuring that an appropriate order is made to provide for sufficient compensation to persons who die in custody, or who die of unnatural causes while in custody. Full stop. Paragraph PIL number so and so is closed. There will be no arrest to pass. Anything that we missed out, anything that we have said that we have not recorded?
Lordship, there are two aspects only.
Yeah.
One is that, Lordship, we had already paid 28 July.
Well, just make a rider. The state says that to the extent that the amounts of compensation have been paid to the next of kin of the relevant victims, and the families have not complained, the court should not enhance the quantum. Full stop. It is also the state's refrain that there has been no express plea by the relatives of the victims or even by amicus curiae appointed in the matter for enhancement of the compensation over and above what has been indicated by the state in its notification. Full stop. Paragraph. As to the sufficiency of the compensation, as to suitability or sufficiency of the compensation, the initial discussion will hold good for the state's objection, irrespective of whether any person has indicated any grievance against the amounts specified in the state's notification. Full stop. Compensation has both to be adequate for the families of the victims and to act as a deterrent so that the state and its officials remain in check. Full stop. The quantum indicated by the state in its notification reveals the amount that the state is comfortable paying. Full stop. If the state is comfortable paying an amount, it almost amounts to endorsing the wrongdoing and perpetuating the same rather than putting in a system that would act as a deterrent. Full stop. This, put it as a rider, we'll add it.
Lordship, small submission. Not to be misunderstood by the state. Lordship, so far Meena Kumari is concerned, my only submission there is, Lordship, it was with regard to that particular facts and circumstances. State is not accepted.
Applies to the same thing. Applies.
Lordship,
We applied.
Lordship, if this is recorded,
No more. No more.
My lord,
We've said that death in custody is death in custody.
Lordship had observed, there was a standard that we have accepted.
Yes.
it's a time frame for payment.
Yes. Thank you. For the above cases, the state should ensure all payments are made to the next of kin upon due identification and verification within the next 6 months. Full stop. period is set as an outside limit. Full stop. If the next of kin are available and make any demand immediately, comma, the state should ensure that the amounts due are paid within the next 3 months. Full stop. As to the amounts that are not collected, whether the next in kin may not be interested or may not be aware, comma, the state will, comma, after waiting for a reasonable period, when no claimant is identified, comma, invest the money in the cancer department of the civil hospital at Shillong as indicated earlier. Full stop. At all times, comma, the secretary in the Department of Health will remain liable to furnish appropriate accounts in respect of the compensation awarded or the compensation made over to the cancer department of the Shillong Civil Hospital. Thank you.
Yes, Lordship.
Thank you. It's really taken us, but at least it's over.
But you never went for appeal if you're not satisfied with that order, Mina Sangma.
Lordship,
You never went for appeal, right?
Lordship, my only submission on that was in a peculiar facts and circumstances. State had not accepted their standard.
They was lucky that the CBI was not brought in Mina as Marab case, my lord, where a minor boy who passed class 12 was killed brutally. He was hit by a helmet by a police officer, my lord, in his head.
Brutally or, sympathetically? How do you make a difference? Life is taken?
Yes.
That is it. That is the yardstick. How the life is taken? Oh, it is made clear that the compensation due in terms of this order in respect of the past cases and future cases will be in addition to any other insurance or other entitlements and not in derogation thereof. Thank you.
from the main list. Item number 1.
How many matters are there? Mr. Khan, how long will we take according to your assessment in this matter?
Lordship, if I just confine to relevant party, Lordship, maximum 15 minutes.
Maximum
15 minutes.
15 minutes. We have to hear him also. Their appeal.
But I think he told me he was heard completely.
No, after such a gap,
Again, my lord.
Okay, Lord.
after such a gap, there is.
But
We'll
Lordship, again, only on last seen theory on 106.
yeah, because we have to look at the evidence and thing.
Up to you, Lordship. Lordship. Because we are coming back again at 3:30. We've got a matter.
There are three. We have the notes, and
I remember, Lordship, in the earlier day when Mr. Bharat, Justice
Yes.
Bhattacharjee was appearing, Lordship said there was a difference of opinion whether 364, 302. Lordship was the opinion only of 364, not 302.
yes,
This is the same thing.
in the last scene theory, Rani is the name of the sister,
Yes, my lord.
and someone says small boy.
Yes, my lord. PW3, my lord.
As far as we remember, both of you please correct us,
Lordship.
and then we can go into the details. You trimmed down your judgments because you thought that we were with you. The judgments that have been cited are 2022 SCC 5535
My lord.
on identification of dead body,
My lord.
2023 Supreme Court. Court will analyze even if the investigating agency has investigation has been shoddy. 2022 live law, not on suspicion, but on the court can't go on the basis of suspicion, but on hard evidence. Then you have relied on an unreported in Shabir. What is the conclusion there?
M. Shabir and my lord, this judgment is same, my lord. This Ravi Mandal. This is the same judgment, my lord.
The same judgment
As in Rahul, my lord.
which is Rahul.
2022 live law, my lord.
So Shabir we've cut out.
No, this is same, my lord. Both the criminals, the accused are separate, my lord. The appeal is one.
No, I know, but 2022 once we are citing, then the Shabir is no longer relevant.
Yes, my lord.
So that's why we cut it out. And then there's an unreported case of Bobby
My lord.
on section 27.
7.
Circumstantial evidence and paragraph 24 to 26. But the incident is like this, that there was a person who is a distant relative of the victim who came to the gate of the house somewhere in Riboy and asked for the boy. Boy was probably 16 or so. Asked the sister for the boy. The sister went and called the boy from inside. The mother claims to have seen the boy talking to the accused, and the sister also saw him talking to the accused, and then they got into a Omni van,
PW3, Lordship.
PW3, my lord.
got into a van,
Lordship, yes.
and then went towards the Guwahati side. So that is the last seen by these two. There's someone else who says that saw a small boy with this person, but let's forget that. Then The police, the complaint was lodged the next day. The police went to the village of the accused, found that the accused had not come to the village for a few days. Never do that, madam. Outside and then in. That's not done in court. And then they alerted the local police stations.
Yes.
And they got news from
Krishna police station, my lord.
let me recount.
I apologize, my lord.
Otherwise,
I apologize, my lord.
Your lordship is correct.
they got news from Krishna police station
Yes.
that he had checked into a line hotel,
Lordship is.
whereupon he was questioned, and he said that he was with the boy in the morning, that they were attacked by ultras.
Correct.
That there was an AK-47 which was
Yes.
wielded at him, and he suffered a buttonhole kind of thing on his sweater or whatever garment that he was wearing, and he was scared. He pretended to be dead, and he ran away. And the next thing is the police comes, investigating officer comes over there, arrests him, and then the body is discovered in a forest near Dudhnoi. There is no evidence of any statement of the accused being recorded
Under 27.
in terms of 27
Very
that you'll
true.
find the body over there.
Very true.
There is no independent witness who reports that the accused led them to where the body was.
That is correct. That is correct.
So what may have happened was the accused may have said that we were in this jungle, and they went to the jungle and found the body from the jungle,
Lordship is.
which does not, kind of point the needle of guilt to the accused.
Lordship.
Now, they also took the accused to some village where accidentally they saw the cook, and the cook was also arrested.
Lordship is correct.
The cook claimed that he was kind of coerced into cooking for them.
Correct.
Initially, he would go to the jungle and supply the food.
And then he-
later, he camped in the jungle, and he saw the boy was, kept in custody in the jungle.
Absolutely correct, Lordship.
That
is
is the
correct.
extent of the cook's statement.
Absolutely correct, Lordship.
We then don't know what happened.
Yes.
There is no direct evidence that the ransom money was paid, but there is evidence of ransom call,
Call and the money accepted.
and at least the money had come, because the accused says the money came, but his share of 10,000 was not paid to him.
Absolutely
The
correct.
circumstances in which the accused left the other 9, it was a group of 9 apparently, left all of them, was also not is not clear.
Correct.
But more than this, he has said nothing.
Absolutely correct.
So today we are left with, yes, the cook was there. Yes, there may have been a conspiracy.
Yes.
Yes, there may have been a ransom threat.
Yes.
Yes, there may have been a case of kidnapping for ransom. But as far as 302 is concerned, you cannot connect the accused with the 302, because we have one, the accused coming to Krishnai, and we have two, the postmortem report, which indicates that the death may have occurred
7 days prior to
7 days prior,
decomposed, Lordship.
decomposed, but when the accused may or may not have, you can't point the accused being in the company of the victim
Absolutely correct.
at the time of the death of the victim.
Lordship is correct.
Now, of course, there is the guilty mind, because there is no trace of DNA found on the garment. So therefore, this AK-47 is a cock and bull story.
Absolutely correct.
So, but the fact that he made up a story may point to something else, his involvement. But it does not point to his having murdered.
Murdered.
Because actually he wouldn't come and say that, no, I kidnapped, No, I did. Ultimately, there is some statement in which he says that his role was only to get the boy to a particular place and nothing else. So, to an extent, kidnapping for ransom probably is established, but 302 is not established. So, we were thinking of letting him go on 302, but kidnapping for ransom also involves the same punishment.
Same punishment. I was about to come to
Same
that.
punishment.
Parameter, the punishment.
So therefore, 364A, we are quite happy, is made out against you. So you are absolved of 302, but the punishment remains the
Remains
same.
the same, my lord.
Remains the same.
Lordship, we're very grateful that Lordship has just summarized it so beautifully. That's why I said I'll just take 15 minutes. Lordship, can I just fill in the gap?
No, you not only fill in the gaps, we also have to give details in our judgment. We can't just.
No, I'll just, right now, Your Lordship, very interesting is the last scene theory. 21st is kidnapped. 21st October is kidnapped.
Yes, the dates. The dates. Yes.
Lordship, 21st he is kidnapped, and who sees him first? Your Lordship, there's a very interesting last scene here. First last scene, and then we'll come to the second part of it. First last scene is seen by PW3.
PW3 is
The person who's distance relative who saw both of them boarding the magic vehicle.
okay. Who says that boy?
Who saw the boy going. 23rd, Your Lordship, is the FIR filed. I'm very grateful, Lordship. Lordship, I'll just connect from where Your Lordship left. The cook saw the boy. Lordship, that was on 27th, 7 days.
Cook to the boy on 27th.
The date is not exactly, Lordship, I'll come to it. Either 26 or 27.
Has the cook been has the cook been
Absconding, Lordship. He was absconding.
cook is absconding?
No, my lord. He was arrested. He is the
was
second
arrested.
appellant.
But, you know, what
He
time?
is the second appellant, my lord, in this case.
After bail, he was absconding. He was.
And cook has been also thing with 302.
Yes, my lord.
Yes.
Under 115, my lord, is the same punishment which is mentioned under 364A. my lord.
364A the cook will also get.
So, Lordship, can
He
you,
will also not get
relief,
302,
my
but
lord.
he will get 364.
so Lordship, what happened was 21st, and then the cook sees the boy alive. The alive is very important, Your Lordship. And that has not been shaken. And we have a lot of circumstances moving around, jacket, all this blah blah story coming in, but alive. Then the body was exhumed on 3rd. Postmortem is of 3rd November. Inquest, Your Lordship. Inquest was done on 3rd November 2015,
Body exhumed
page 96, Your Lordship.
3rd November
2015.
and postmortem
Postmortem is on 4th.
7 days prior.
Lordship.
Decomposed,
Decomposed. But
identified by father,
father and Ranjit was the first person, Lordship, PW6.
but identified by father.
Identify the father, yes.
And one of the points he has made that no DNA, nothing.
No,
How can I decompose? That's why close it can be done.
Lordship, I'm into last scene theory right now. First scene by PW3, then we stop, pause for a minute when the cook saw the boy alive. That's very crucial. And there are other evidence which PW11 has brought about in his in chief. Movement, bullet injury, everything.
Who is PW11?
Food is the IO. His evidence is very, very important. Already. He is the person who has narrated everything in chief, and that has not been shaken. So again, I come back to body exhumed on 3rd. In the inquest report says one thing: the body decomposed for 7 to 8 days. Same thing the doctor says, Lordship. Decomposed could have been for 7 and 8 days. So now, Lordship, we go back 7 and 8 days. From 4th, 7 and 8 days would be either 27 or 28.
Let's go to 27th itself.
Lordship, yes. So thankful, grateful, Lordship. So the moment we come to 27, now I'll come back to my primary argument, Lordship.
27th is when he was in Krishnai.
Krishna. And Lordship, very important thing is this: last scene theory, there is no death in the middle. The boy is still alive.
Yeah. Now, when did he surface at the Line Hotel in Krishnai? 27th. He was arrested on 30th.
30th,
So was it on 29th? He came on 29th.
29th. I don't know exact date, Your Lordship, but
No, the date is there.
20,
In PW11's thing.
PW is 11.
Page 48 at page 53. Twenty-ninth.
29, sorry.
Page 49. On 29:10 at morning time at
27th, my lord, I beg to differ. It's the last paragraph at page 49, my lord.
page.
Page 49, my lord, last paragraph.
That on 27:10 they received a call from a line hotel located in Salpara. So therefore, from 27:10.
Which page? Page 49. Last paragraph.
Yeah. So, Lordship, assuming, Lordship, we take 27. So, Lordship, from inquest report and post-mortem report, we go back 7 days.
27th is possibility.
So, Lordship, I'm admitting, Lordship, there is no exact evidence.
The possibility.
Possibilities. So now, Lordship, the possibilities is from 21 to 27. We go ahead, and from 4th we take back to either 26 or 27. No evidence, but these are the 2 days very important. In these 2 days, Lordship, the second leg of my argument, Lordship, is this: in these 2 days the boy was alive. You have evidence enough to say. Now the question comes: if the boy was alive, PW3 saw first, and if he is alive, so what happened between 26, 27 till the body was exhumed? First, Lordship, we will have to overcome 106 discharge.
No. 106 has no role to play over here.
No, Lordship.
On your own case, 106 has no role.
Lordship, I'll just maybe Lordship, I'll just make an attempt, Lordship.
No,
I'll pursue the Lordship.
we'll just tell you why 106 will have no role. According to your IO, there are 8 or 9 people involved.
Yes.
And one was arrested, obtained bail, absconding.
Yes.
The others could never be apprehended.
Yes.
So therefore, it's not only the cook and not only the principal accused.
There are many.
There are others. So then, no explanation. Next is, why did he lie?
That I'll come to it, Lordship. Lordship, first of all, Lordship, let us overcome this. Lordship, how would you, Lordship, appreciate PW1's in-chief statement? I'm putting this question to myself. If it was not shaken, can we take the entire in-chief as admissible statement? If we agree to that, Lordship, then I'll bring this fact.
PW1 is the father.
PW11, Lordship.
PW11.
11, Lordship.
PW11 is police. You have to take it with not pinch. We have to take it with ladles of salt.
Lordship is correct. But Lordship, if he has made certain statement, then there's a lot of statement that comes from PW11.
Yes.
In the in-chief. If we take everything, Lordship, whether it favors the prosecution or not, that's a different story.
Yes.
So, Lordship, if we take the entire statement which is not even shaken,
Yes.
among one of the most important statements, Lordship, is at page 54.
Page
54. If it was shaken or contradicted, we cannot rely on Lordship. But if it has not been shaken or contradicted, or neither he is retracted in his as before.
Yes.
Lordship has got it page 54.
52,
54.
54, yes.
From the bottom, Your Lordship. Only in the issue of the accused acquit R. Marak and was put to sit together for further interrogation. And during interrogation, both of the statements
Then
contradictory to each other,
sit together for further and during,
voluntarily confessed as a victim. P.T. Small was killed and thrown in the reserve forest. Lordship, allow me to pause. I know Lordship will have a strong disagreement.
completely barred by section 25. Can't even look at it.
Lordship, section 25 would be barred during investigation. That's why I said, Lordship, this is a statement on oath before the court.
Maybe,
Before the court.
maybe. But when does he attribute the statement to have been made? He attributes it as a confession.
Lordship, correct. But Lordship, had we relied on the 25 before investigation is a different thing. I know, Lordship, I'm making a difficult argument. But this is on oath. Lordship, for a moment, the accused had two options. We are only in the factum of death. Either the defense would have crossed saying that you have not made a statement under
What is
145.
25? Please read
25 is inadmissible. Lordship.
Please read 25.
Lordship is inadmissible.
Please read 25.
Inadmissible.
No, that's not the main part.
It's
Main part of 25. Please read 25 once. Just humor us. We learn every time.
Lordship.
Read 25.
Confession of an accused while in custody of police not to be proved against him.
Confession of while in custody he made a confession. It cannot be proved by anything. So subsequent statement that he confessed while he was in custody is of no value.
Lordship, the same problem that we have in 27. I'm afraid, Lordship, I may be wrong, but I'm just trying to bring this point. Had we relied on the confessional of made in 25, and then we would have corroborated, then the option for the defense would have been under 145 to say this is inadmissible.
No. The statement over here is that while Ajay and Acquit were in custody,
Lordship, yes.
they contradicted each other, we made them sit in front, and then a confession came. Yes, what he is saying is not barred,
Correct.
but what he is referring to is barred.
Is barred, yes. Lordship.
So therefore,
There is a distinction, Your Lordship. Referring to will be barred. No, Lordship, kindly allow me because this is made on oath before the court.
so
Lordship, the only way to contradict is 145. If I may just take your Lordship to 145.
yes,
145 of the Evidence Act.
yes.
Cross-examination to the previous statement in writing. Cross-examination to the previous statement in writing. There should be a statement of confession in the case diary on 162 or on section 25. First of all, it cannot be proof, but if that statement is brought in cross, that is the only way the cross can bring in. Lordship, it does not come. My respect for submission, Lordship. It's a very finer point of law, Lordship. Kindly allow me to address this. Again, I'm making a submission, I may be wrong. In that situation, this would not be applicable.
We really don't follow you.
Lordship, first there has to be a statement under section 25 in the investigation. And if the prosecution has taken out this in the in-chief, saying that you have made a statement there, it would be a futile exercise because it ought not to be proved. The prosecution has not relied on the section 25 or any other statement made before the investigating officer while in police custody.
Why?
This Lordship. If it doesn't make, then it's not covered under section 25. The same problem that we find in section 27.
This is the same statement he has made.
But Lordship, the previous statement under custody was not brought before the court. For neither the defense crossed him on that. In other words,
A
Lordship,
statement in terms of section 25 need not be in writing. The statement can be orally made. But if the police officer records that he confessed
Lordship, yes.
and brings that record and proves it, It's inadmissible.
Inadmissible.
Then the same police officer cannot
Lordship.
orally say that he confessed and that would be admissible.
Lordship, my only purpose is this: if he makes an oral statement, what is the law? No, Lordship, can you appreciate?
No.
If he makes an oral statement,
Inadmissible, it is inadmissible. They are not required to do anything. If a recording of that statement had been produced, it would have been inadmissible.
Lordship is correct.
If an oral account of that statement is given, it's still inadmissible.
But Lordship, can you appreciate? So far, this is concerned. It has not been shaken.
The only way it can be proved in this kind of a scenario is that there are 3 other independent persons who come and say, in our presence, he said this to the police voluntarily. Then it has some evidentiary value.
Lordship is correct.
The 3 others corroborating, if it can be proved that they have no motive against him, they are really independent and disinterested, then it's their statement, not the evidence given by him to police. Not the
Lordship,
confession.
absolutely correct. No correct.
Their statement of his confession, which is admissible.
Admissible. Here, Lordship, we don't find, Lordship, I was just trying to bring in because 145 doesn't contemplate.
145 will arise in a situation where they are required to do something. A statement made by a witness, if it is not contradicted, whether by suggestions or by counter questions, then is deemed to have been accepted. That is an old rule. The rule is enunciated in 1961, Calcutta is the best judgment for that. Quoted subsequently in Supreme Court also. But that principle won't apply. Inadmissible evidence would not become admissible because it has been referred to in chief and not contradict.
Lordship, if I can't sustain this argument, then maybe
You cannot.
then the case of murder is in a very shaky ground.
You cannot sustain this argument at all.
Then Lordship, I will not press.
No, because Mr. Khan, once again, that's why we read 27.
Yeah, absolutely.
Read 25.
Lordship is correct.
25 comes up to 24.
24.
There are 2 situations. In custody and in presence of.
Correct.
Look at 24, look at 25. Then look at 26.
Yeah.
And then 27 as an exception.
Yes.
24 is a confession made by an accused is irrelevant if in making confession it appears to have been caused by inducement, threat or promise having reference to charge, opinion to give the accused whatever. That's 24. 25 is no confession made to a police officer shall be proved.
Absolutely correct, Lordship.
So this is a confession made to a police officer which you're trying to prove.
Lordship,
It does not say.
Lordship, I will not forward it because I was just trying to say there was nothing to brought in record for the defense to cross-examine.
No. This is how you're doing it. There could have been a slip in which it could have been recorded. You could have produced that as an exhibit.
Still, it will not be admissible.
That would not be admissible.
Absolutely not.
Here, you are giving. What are we doing when we are making oral statements? Not everything can be recorded, reduced to writing. So what we are creating the scene ex post facto for the court to understand from there as a third person not really present to kind of imagine that the court was there, a fly on the wall, looking down on what was happening with its imagination based on the statements adduced before it. Now, once it is said that no confession made to a police officer shall be proved, what you are trying to do is completely contrary to that provision. Confession made to a police officer, which he tries to assert in his
Oath in chief.
examination in chief, has no value. So they are not liable to either respond to that or needlessly put their head on the chopping block.
Because, Lordship, this was very important. So, Lordship, there is no other witnesses who is supporting this. Now, Lordship, if this argument cannot be sustained, then, Lordship, in the last scene only, I'm just trying to forward another argument. The Border 106.
Last scene,
It looks very shaky, Your Lordship. I'll admit, Your Lordship.
we accept that. You don't need to have to go to that. On the mother and the sister statement, it is apparent that he went with the accused.
Lordship, I'm into the second part of last scene. First part, going part is okay. The alive part. No, if you take the postmortem back 7 days, and if you take the cook statement, that means the boy was alive.
Yes, there's a possibility, but you have to prove beyond reasonable doubt.
Lordship is correct. That way, Lordship, the murder cannot be sustained. I mean, candidly admit, Lordship, because there were so many other people around. Had there not been anybody around, maybe yes.
Yes.
So that's why, Lordship, I said, if still we can nail him by PW1 state 11 statement, then maybe otherwise, Lordship, is a case of 364.
My lord has just fallen from my lord that the sister statement, my lord. The sister was never examined, my lord, neither by the police nor before as a PW, my lord.
Sister was gone, mother was examined.
Mother was examined, but in the cross examination, she has said that she did not see the accused with the son.
With the card. No, she has not seen.
She has not
But
seen.
she has seen the accused outside?
No, my lord. In her chief, my lord, in a PW, she has admitted, my lord, before the police, she has stated that I had seen the accused when I came out of the house out of curiosity. But as a PW2, my lord, she has not said. She said that I did not see the accused going with my son.
Going with my son.
Yes.
That does not mean I did not see the accused.
No, my lord, I
But
did.
she also recounted that her daughter told her that the accused had called for the brother.
My lord,
Where is her statement?
the statement is at page 34, my lord.
Who is the cook? Cook is acquit.
Acquit, my lord.
Why does the father say Ajay was arrested from Borjar, Garopada? Very well, yes. Where is the sentence?
Sentence.
64 with 10 to 34.
Sentence. This, there is a separate paper book, my lord. Supplementary paper book 2, my lord.
Yes.
This sentence is mentioned there.
What is the date of the impugned judgment?
14/11/2019, my lord.
And sentence on the same day. Yes.
Yes, my lord. Yes, my lord.
Very well. The appeal is direct. There are two appeals.
There are two appeals.
The two appeals are directed against a common judgment and order of sentencing of November 14, 2019, by which both the appellants have been found, by which both the appellants have been convicted under Section 364 capital A and 302 of the Indian Penal Code 1860, read with Section 34 thereof. Full stop. Paragraph appellant Ajay Sangma has been sentenced to rigorous imprisonment for life, together with a fine of rupees 1 lakh. In default of payment of fine, the convict is to undergo simple imprisonment for a further year, running concurrently with the period of conviction. Paragraph. Appellant Acquit R. Marak has also been similarly, same sentence,
Same sentence.
has also been similarly punished for his role in the matter. Paragraph. On October 23, 2015, the father of a 16-year-old boy lodged a complaint with the Pilankata police outpost in Riboy district to the effect that on October 21, 2015, his son went out of their house along with the appellant in the first matter of Chibra village, but did not return. The FIR also narrated that on October 22, 2015, at about 11 a.m., he received a phone call from an unknown number, 708-568, 6169, demanding a ransom of rupees 10 lakh for the release of the complainant's son. The complainant specified that the caller's spoke to the complainant in Garo and Assamese language and warned the complainant against reporting the matter to the police. Full stop. According to the investigating officer, who was examined as PW11, the sister of the missing boy apparently told the IO that she was examined by the IO.
Never felt.
Nothing.
No.
Then cut out this paragraph. According to the investigating officer, inquiries revealed that the appellant in the first matter, Ajay, came looking for the victim on October 21, 2015, and after the victim came out of his house and spoke to Ajay for some time, the two of them got into a car and drove away towards Sriboy, towards Guwahati. Full stop. The IO also revealed that he visited the village of Ajay but discovered that Ajay had not been in the village for several days. Full stop. The IO also claimed that he informed the neighboring police stations in Assam of the incident so that they could keep a watch out. Full stop. Paragraph. According to the IO, he received information on October 29, 2015 that Ajay was in a lined hotel within the jurisdiction of Krishnai police station. Full stop. Upon seeking further information from the officials at the Krishnai police station, the investigating officer discovered that upon what do you say?
Seeking further information from the officials.
The investigating officer came to learn that Ajay had been rescued from a nearby jungle and brought to a line hotel in Krishnai on October 27, 2015. Upon a local police personnel questioning Ajay, Ajay revealed that he was in the jungle with the missing boy in the morning of October 27, 2015, when they were attacked by ultras And in their individual bids to escape, they got separated. According to Ajay, he was shot at by an AK-47. As a result whereof he sustained a bullet injury on his jacket. Full stop. Paragraph. Tests conducted on the relevant jacket, however, revealed no DNA trace of any bullet, nor was any bullet discovered. Full stop. Ajay was arrested on September 30. Full stop. He applied for bail and obtained bail. Initially, however, he had initially, however, this shall be the previous slide before initially.
He applied for bail and obtained bail initially, however,
He applied, who?
he applied for bail. Ajay, he applied.
No. Forget that. Just before that.
Conducted on relevant jacket, however, revealing the images of bullets, nor any bullet was discovered.
Full stop.
Ajay,
No. The IO narrated that he led Ajay to some place where the other appellant, acquit Marat, was found accidentally and was arrested since Ajay informed the investigating officer that acquit used to cook for them while they were in the jungle with the boy. Paragraph. Acquit apparently told the investigating officer that he was coerced into supplying food to all the persons who had kept the boy confined. He also told the IO that he was subsequently required to stay in the village and move with the rest of the team since they did not stay put in one place, lest they be discovered. Acquit claims that he had nothing to do with the matter except cooking, though he admitted that he had seen the victim alive. Paragraph. It is the further testimony of the investigating officer at the trial that Ajay and Acquit made contradictory statements, as a result whereof both were questioned together and they confessed that the boy had been killed and had indicated that they would lead the police to where the body of the boy was buried. Full stop. Much emphasis has been laid on the IO's statement to the effect that the then accused had confessed to the IO of having kidnapped the victim and having kept him in solitary confinement for several days. Full stop. The mother, just start. According to the IO, several persons, probably 9 in number, were involved in the entire operation of kidnapping the boy for ransom. Full stop. Of the others, one was arrested for a short while, but he absconded upon securing bail, while the others could not be apprehended at all. Full stop. The IO described how Ajay led them to where the dead body was buried, and how the dead body was exhumed. Full stop. This was on November 3, 2011, whereupon an inquest was held and the dead body was identified as the victims by the FIR maker, father of the victim. Full stop. The body was found in a state of decomposition, and the postmortem report of November 4, 2011 revealed that the death may have taken place some 7 or 8 days before the post-mortem examination was conducted on the body. Full stop. Paragraph. According to the state, in view of the nature of the extent of the decomposition of the body and the medical evidence in such regard, it can be safely be presumed that the boy was alive on till or about August 27-28, October 27-28, 2015. Full stop. The state also refers to acquit claiming to have seen the boy alive. Full stop. According to the IO, Ajay claimed that the ransom money had been received, but for reasons not understood by Ajay, Ajay was not paid his share of rupees 10,000. Full stop. Ajay claimed that he did not make a hullabaloo at the relevant point of time, full stop. However, it is evident that the story that Ajay spun of being picked up by ultras or being shot at was a figment of his imagination, since the DNA analysis of Ajay's jacket with the alleged bullet hole therein did not reveal the remains of anything remarkable. Full stop. Paragraph. Though the body was exhumed from a forest near Dudhnoi on November 3, 2011, 2015, there was neither any recording of any statement by either accused nor any independent witness to demonstrate that one or the other of them had led the police team to where the body of the victim was buried. Full stop. What appears from the evidence is that both the accused or either of them may have revealed where the group may have kept the boy in custody, and the police scoured the area to ultimately discover the body, not at the behest of either Ajay or acquit. Full stop. Since there is no evidence in such regard, it cannot be accepted that either Ajay or acquit led the police to the place where the body was interred. Full stop. In the absence of Ajay being linked to the discovery of the body, or the knowledge that the victim had already expired, no charge of murder can stick against Ajay. Full stop. Even if it is accepted that Ajay's story that he met with ultras on the morning of October 27, that they shot at Ajay during such time is disbelieved, it does not necessarily follow that Ajay murdered the boy or that Ajay was involved in the commission of such events. Full stop. Paragraph. Indeed, what such dishonest statement of Ajay reveals is that Ajay may also have been apprehensive that victim would be discovered, and if the victim had claimed that he had been abducted by Ajay, that would have that would have reflected poorly on Ajay. Full stop. In such circumstances, Ajay may have made up a story of Ajay and the victim having been kidnapped. Full stop. Paragraph. The father of the victim identified the body, but, according to such father, it was Acquit, not Ajay, who led the police to the body. Full stop. Apart from such anomaly, since the investigating officer claimed that it was Ajay who led the police team to the body, it is evident that the boy must have died on or about August 27-28, October 27-28, 2015, by which time Ajay had already come away. Full stop. From the impugned judgment, there does not appear to be any basis for holding Ajay and even Acquit guilty of murder. Full stop. Indeed, it is evident that neither Ajay nor Acquit may have been a part of the group as of August 27 or August 28, October 27 or October 28, when the boy may have been killed. Full stop. In the light of Acquit only claiming to have been the cook, and Ajay confirming such position, Acquit cannot be seen to have had a big role in the entire operation. Full stop. On the basis of the material before the trial court, neither Ajay nor Acquit could have been found guilty of having committed murder. at any rate, comma, no motive has been attributed to either, full stop. As to the charge pertaining to kidnapping for ransom, it appears that the same has been made out. In view of the FIR maker's assertion that he had received a phone call and a corroboration of the situation by the accused, to the extent, comma, at least that what did I say previously? To the extent that, before that,
Asking the charge pertaining to kidnapping for ransom, will appeal to the same has been made for in view of the FIR maker's assertion that he had received the phone call and a corroboration of the situation by to the extent, at least.
of Ajay having lured the victim from home and admit having seen the boy in the company of the group for which Acquit was apparently forced to cook. Paragraph. Even if the charge of murder against both Ajay and Acquit is set aside on the ground of insufficient evidence, comma, the case under section 64A of the Penal Code has been adequately made out. There is evidence of Ajay driving away with the victim, evidence of someone or the other contacting the parents, contacting the father for ransom money, and the assertion by Ajay that the money may have been paid, though Ajay's share was not made over to him. Full stop. Whether or not any ransom was actually paid there is no denying the fact that the victim was kidnapped, full stop. In the light of the father's assertion as to the phone call demanding ransom, it further appears that the victim may have been kidnapped for ransom. As such, even though the charge of section 302 of the Penal Code may not apply in the present case, the punishment awarded to either appellant for kidnapping for ransom would have to be left untouched. Accordingly, criminal appeal number 32 and criminal number 33, both are 32. There are two appellants.
Two appellants.
Accordingly, criminal appeal number 32 of 2022 is allowed in part by setting aside the judgment and order dated September 19, 2023, insofar as they convicted Ajay and acquit for having committed murder, but they are both convicted under section 364A for kidnapping for ransom. Accordingly, the punishment under section 302 is set aside. Insofar as it relates to the charge under section 302 of the Penal Code, the conviction under section 364 capital A read with section 34 is upheld. Paragraph nothing else. Do we need to add anything? Just have to make some corrections, some parts. I've gone. Anything that you want included or excluded, Mr. Khan?
Appeal is partly allowed.
Huh?
Appeal is partly allowed.
Appeal is partly allowed. That is.
That is gone.
Yes.
But Lordship, highly grateful, Lordship. At least that part has come out very well. I was listening to
Yes.
Lordship. That Ajay led to discovery.
I'll just look at some of the things. It's a slightly tired mind, and I'll make some corrections.
Ajay led to discovery by the IO, and actually the PW1 making statement acquit led to it. So that is a
Yes, that is the thing.
Lordship, that is a contradiction.
That is the
So
contradiction.
that can't be protected under section 8 even.
That is the contradiction that I pointed out also.
Lordship is very correct. That is the case of clear contradiction.
Yes.
My lord,
Had it not been for that, Lordship, I would have argued.
However, since the sentences in respect of the two distinct offences were to run concurrently, notwithstanding the acquittal under section 302 of the court, the sentence of rigorous imprisonment for life, together with a fine of rupees 1 lakh under section 364 capital A, is sustained. The additional fine of rupees 1 lakh for murder is set aside. Thank you.
obliged, my lord.
One point.
My lord, this matter was last heard on July 19.
Yeah.
My lord, whatever my lord has recapitulated is exactly the same, my lord, not a word missing till today, my lord. It's been about 40 days after the matter has been listed again today.
Several judgments have been cited on behalf of the appellant, including the ones reported at, just give me the page, including the ones reported at AIR 2022 SC 5535, find out the thing. AIR 2023 SC 634 and 2022 Live Law SC 926 give the cause titles. Full stop. In addition, comma, an unreported judgment, Bobby, has also been cited. Full stop. In view of the facts as they presented themselves and the facts and the evidence not sustaining the charge of murder, comma, the law on such aspect of the matter as cited on behalf of the appellant has not been referred to in any great detail.
Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
Yes, what is the progress made, Mr. Khan? If you're not sick of me already.
Lordship, the other day, last week, I saw Rajiv, Senior Advocate Rajiv Dhawan arguing. He started at 10:30, took up till 1 o'clock, and there was a break for 1 hour. Then he started at 2 again, till 4:15. Then Honorable Chief Justice asked him, how long will you continue? He said, tomorrow for two more hours.
Yes.
Lordship, we have made some progress, substantial progress.
What about the
DP, Lordship,
criminal cases?
Criminal code-
It's filed.
Lordship, it's in the final stage. We're just waiting for sanction. I'll just give the report.
Waiting for sanction.
Sanction, Lordship. Lordship, we kindly have it. It is at page 5.
We want that process to be started. Thereafter, law will take its own course.
Absolutely, Lordship. Absolutely.
Wash our hands off.
Absolutely correct, Lordship. Lordship will see page 5, status of investigation.
A status report has been filed by the state pertaining to disciplinary and criminal proceedings against the respondent number 7.
Criminal case is at page 5, Lordship, and DP is at page 6.
Page 6.
Page 6, cross 7.
Paragraph.
Paragraph 3, 4, 5, 6, 7, Lordship. These are the latest is the page 7, para 7.
Not much progress has been made in the discipline proceedings since the presenting officer appears to have been on leave and, upon rejoining, the presenting officer was diagnosed with typhoid. Full stop. It is hoped that the presenting officer has not only covered to carry the disciplinary proceedings forward in accordance with law. Paragraph as to the criminal proceedings.
Page 5, Lordship, cross 9.
The charge sheets have not been filed yet, though
Only one. 10, only one has been filed, Lordship, 10A.
the charge sheet has not been filed in 4 cases, though in one matter the charge sheet has been filed and the government has wanted sanction to prosecute the respondent number 7. Paragraph, it is hoped that charge sheet for appropriate reports would be filed in respect of the other criminal cases in accordance with law. Full stop. The matter will appear 6 weeks hence for a further status report to be filed by the state.
Highly obliged, Lordship.
Item number 2.
May it please the Lordship.
Yes.
My Lord, I'm entering appearance on behalf of the sole respondent.
You're appearing for the department?
My Lord, yes, for the
Yes.
respondent.
You're appearing for the SSC?
My Lord, I'm appearing
for the department, Lordship.
I'm the SSC, my Lord.
Oh, you're the SSC? Yes, you're for the department, sorry. And yes, so let's
If
proceed.
Lordship permits, my Lord, I would like to file my objection, my Lord, to the application for condonation, my Lord.
How much delay is there?
My Lord, 821 days, my Lord.
How much?
821 days.
Yes, tell us what is your objection, we'll note it.
My Lord, I would like to file it through an affidavit.
We'll condone it.
My Lord,
It's our satisfaction, not your satisfaction.
my Lord, if we may be at least given an opportunity to file an affidavit, my Lord.
Prima facie, it appears good grounds have been made out for condonation of the delay of about 821 days. full stop, paragraph, however, comma, inasmuch as the SSC seeks to file an affidavit, comma, let the matter stand over for a week
My lord.
for the affidavit to be filed within such time. List the matter, give a date 1 week hence.
My lord.
I'm obliged, Lordship.
Item number 3.
It's still pending.
Lordship.
Since there has been no further progress in the matter before the 9-judge bench of the Supreme Court, where the legal issue is still pending, comma, let this matter appear 3 months hence. Paragraph, the parties will have liberty to mention for an earlier listing immediately upon the earlier disposal or immediately upon the disposal of the Supreme Court case, give a date 3 months hence.
Obliged, Lordship.
Item number 4.
My lord. I'm for the appellant, but I was
Yes,
going
sir.
for some accommodation, but I'm not feeling a little well. Any day, my lord, tomorrow, day after tomorrow.
What is the issue?
Well, here, my lord, the respondent was appointed as some scientific post, my lord, in
Oh, very well. Since the appellant seeks an accommodation, let the matter appear a fortnight hence.
If it can be, my lord, my only thing is, though there is an order in my favor, my lord, but since it has been challenged in the appeal, my lord, they have not implemented, your lordship. So I am in the middle of my service career, your lordship. If it can be taken up next week, your lordship.
Very well, let the matter appear a week hence.
Obliged.
Item number 5.
Please, Your Lordship, the conducting counsel is on sanctioned leave. S. Kumar, Your Lordship, will be coming after 8 of
Is that
September.
my lord.
recovery without compliance?
I'm conceding this.
An adjournment is now sought on behalf of the respondents, comma, let the matter appear a fortnight hence.
Deeply obliged, Lordship.
From the Mingus, item number 1.
Please, Your Lordship.
Yes.
Lordship, two requests. Firstly, Lordship, against this matter, transfer petition had been filed before the Honorable Supreme Court.
So that is now irrelevant.
That is that has worked itself out.
Yes.
And for 2 weeks since I wish to file a compilation of documents which will be relevant in the adjudication of the
What is the issue?
The issue concerns the erection of check gates by the Imam along Sirdarship along the national highways.
Very
and
well.
also
You will withdraw the transfer petition.
yes, Lordship, that will be.
There is a delay.
Yes, there was a delay,
How many days?
Lordship, 30 odd days, if I'm
Very well.
not a long day.
The application for condonation of delay could not be listed earlier since a bench could not be constituted in this court to take up the matter. Paragraph, the applicants have applied for transfer of the matter to some other high court. Full stop. Since a bench has now been constituted, comma, the applicants submit that the relevant petition for transfer will be withdrawn. Paragraph, since the transfer petition is pending, comma, the matter is not taken up, even for considering the condonation, prayer for condonation of delay, full stop. Further, comma, the applicant seek leave to file a compilation of documents that will be relevant for consideration in the appeal. Paragraph, let the matter appear 4 weeks hence, full stop. It is recorded that if the delay is condoned, comma, the appeal will be taken up for immediate consideration.
I'm obliged.